Welcome back, AHOA, as we now address point number 9 in our 12-point series on fair franchising. Point number 9 is an important point, and it involves venue and choice of law, which, as an attorney by training, these are two concepts that I definitely want you to be aware of. Please watch series number 1 through 8 so that you have the full background and the education on what we're trying to teach you concerning the AHOA 12 Points of Fair Franchising. We would also strongly encourage you to pick up a 12 Points pin if you have not done so. We're hoping that everybody will start wearing these to really send a message that we care about pursuing victory after victory in the battle for fair franchising. Again, why are we doing this? It's to sustain the franchising business model. Fairness in the industry will make all the difference in the long term. And then to talk quickly about the tools that we have available. On the AHOA website, you can pick up the AHOA 12 Points, the educational primer, which has each of the 12 points, specific details about the reasons behind them, as well as commentary on why we think these are important for you to know, you to understand as you're reviewing your franchise agreement and speaking with your franchisor and negotiating with them. On that point, you can also download the AHOA 12 Points questionnaire from the website. And the questionnaire is a very useful tool. You can use it to ask questions of your franchisor. You can use it to ask questions of yourself to determine which points are the most important to you. And you can look through your franchise agreement, and especially if you've retained an attorney to assist you, you can review them together and you can determine which issues are the most important, which terms are key for you to negotiate. So with that, let's then look more closely at point number 9, which is on venue and choice of law clauses. In the event there's a dispute between the franchisor and franchisee that has not been resolved by participating in an informal meeting or a mediation, as we discussed with point number 8, then we would highly recommend that the party be able to pursue its claims in a court of law and should do so in the county and state in which the subject facility is located. Now, what do I mean by that? Well, instead of having a mandatory arbitration proceeding or a legal proceeding in the backyard of the franchisor in the city or the state in which the franchisor's headquarters is located, instead, it should be where your hotel is located. Indeed, the franchisors have ample resources. They can hire attorneys, they can easily come to the state where your hotel is located, to your county, to your city, instead of you, as a small business owner, being required to travel to them. Let's make it fair and bring it specifically to wherever the facility is located. Further, any lawsuit or claims should be governed by the laws of the county or state in which this lawsuit or proceeding is filed. And again, that would mean where your hotel is located. Finally, a confession of judgment clause should not be included or part of any franchise agreement or any corresponding contract, rider, attachment, or promissory note carried by the franchisor. And in order to determine whether you have these provisions in your franchise agreement, again, we would recommend that you go to the questionnaire and you look up point number 9. And I will share with you, there's 3 questions there that you can review either with your own attorney or with the franchisor. Number 1, the first question for the franchisor. In the event a dispute between you and a franchisee has not been resolved via an informal, in-person meeting with authorized representatives from the parties, do you agree that a party pursuing its claims in a court of law should be allowed to do so in the county and state in which the subject facility is located. Again, that's to find out what their provisions say. Second, do you agree that any lawsuit or claims should be governed by the laws of the county or state in which the lawsuit or claims are filed? And again, hopefully that is in the county or state in which your subject facility, your hotel, is located. And third, in your franchise agreement, do you disallow a confession of judgment or corresponding contract, rider, attachment, or promissory note carried by you? So that is point number 9. And so if you have further questions, we would invite you to contact us here at the AHOA office. We can review them for you. I'm also going to have another industry leader talk to you for a few minutes about point number 9.
Well, point number 9 is key to me because the franchise agreements are notorious for containing choice of law and venue language that favors the franchisors in a one-sided manner. In my opinion, I believe that any dispute with the franchisor and the law that should apply to that franchise agreement subject to that dispute should be resolved where the property is located. While some states prohibit franchisors from requiring franchisees to waive application of a certain state's franchise law, in most states, that's not exactly what happens. Most disputes between the franchisor and the franchisee are litigated and resolved in the franchisor's home turf and applying the franchisor state law without regard to the franchisee's Franchise Protection Act. Well, when we were first starting out, we got into a franchise agreement with the franchisor to develop a new hotel. While we were in the process of developing that hotel, the demand generators for that area no longer made it feasible to build the number of rooms that the franchisor was requiring. When we attempted to raise this issue with the franchisor, essentially what we received was crickets. Then all of a sudden, about a year and a half later, we were served with a lawsuit for payment of liquidated damages and to resolve that dispute in a state I've never been to at the time. While we resolved that issue, the costs and expenses that we incurred were only taking away from our life savings to put into the franchisor's pockets when we got zero in return. I can't exactly fathom the idea of how franchisors are able to get away with it. I'm very happy that point 9 addresses that exact issue.
So thank you again for joining us for point number 9 as we continue in this battle for victory after victory in fair franchising. Your support of AHOA is so important as we continue to learn about each of the points of fair franchising. We welcome you to stay tuned. Point number 10 will come to you shortly. And of course, again, remember to wear your 12 points of fair franchising pins. And we look forward to seeing you at the AHOA convention as we gather together to support these issues. Thank you again, and we will see you there.